Good afternoon, everybody. Welcome, welcome. I know you've just been served your lunches, so you can certainly continue to eat and munch while we get the program underway, but we do have limited time, so I'm going to go ahead and get started. I want to welcome all of you. In case you don't know where you are at the Bench Bar Press Annual Luncheon, and I want to welcome you on behalf of the committee and all of its members. This year we have a really great opportunity, which we jumped at, which was to partner with the Ninth Circuit Courts and Community Committee, of which there are 4 members here today. So I would like to introduce them. Judge John KRONSTADT of Los Angeles is here, and we're going to ask Judge KRONSTADT to come up in just a minute to give you a few brief remarks. Also, Attorney Kelly Sager from Los Angeles is here. District Court Clerk Sean McAvoy of Spokane, and Assistant Circuit Executive Director David Madden. So welcome to all of you, and thank you so much for partnering with us. So at this point, I'd like to ask Judge KRONSTADT if he would come up and just say a few things maybe about your committee and this collaboration.
Well, I want to thank all of you for inviting us and letting us join you so we can benefit by learning from you. And I wanted to thank Chief Justice MADSEN as well as District Judge Lasnik, because the Washington courts, the federal and state courts in Washington, have been leaders in the efforts involved, so we're grateful for that opportunity. I'm a new member of the Ninth Circuit's Court and Community Committee, which is in our chair, Judge Sammartino, regrettably at the last minute couldn't be here, so I'm standing in for her, and she's a long-time and dedicated participant in the committee, as is David Madden, who's here, you've introduced. The mission of the Ninth Circuit's committee, which has been in place for 15 years, is twofold. First, to facilitate relations between courts and the media, and the committee has overseen more than 14 conferences in that, and plans others. Kelly Sager's here, and she's working with others to facilitate the next one. The second purpose of the committee is to promote community outreach, meaning to increase awareness of and understanding of courts among community members. And for example, this year, throughout the circuit, it's going to be a contest encouraging high school students to make submissions, essays, and videos on the 50th anniversary of the Miranda decision, a decision that was a court decision and where those rights continue to be protected by courts. Several districts will have their, including the Western District of Washington, will have separate contests, and then they'll be funneled together for the circuit-wide contest. Prizes will be provided to the winners both in many districts as well as circuit-wide, and the high school students who win the circuit prize will be invited to the Ninth Circuit Conference. So that's an example. My own work in the past, and part of what the committee will also be doing, I mentioned phase 2, which is understanding of the courts and reaching out to the community. The civic education is not something that has continued to have the same priority in our schools as it formerly did. And accordingly, it's really important, in my view, that courts, along with partners, do our best to bring knowledge to students about our system. And the Constitutional Rights Foundation, which I've been involved in Los Angeles, does that through mock trials and courtroom-to-classroom programs where judges and lawyers go to classrooms to talk about actual Supreme Court cases, and where the students do the mock trial, being the justices of the Supreme Court. We have power lunches where students come to courthouses and meet with lawyers and judges, and we have teacher institutes where those who are teaching these subjects come to court. So these are all opportunities for, as I always put it, showing kids democracy matters, showing our citizens the same. So thank you for having us. We're here to learn.
Thank you, Judge Kronstadt. And it does sound like you have quite a few very interesting projects underway already. So anything we can do to help in your nascence, we're more than happy to help. I also wanted to remind everyone here, not that you will all stay, but we do have a business meeting that will be following the panel. And at that business meeting, we're going to say a very sad farewell to a couple of our longtime board members. Mark Allen from the Washington State Association of Broadcasters will be leaving our board. And George Erb, who was formerly with the Puget Sound Business Journal, and they'll be retiring from the committee. There will also be a fire brigade report, and I believe we'll also hear from the Washington Coalition for Open Government. So those topics might be interesting to you, and also just a few words about our GR 31.1, which is our public records court rule. So we'll be talking a little bit about the rollout of that court rule. Enough about the business meeting. On to the panel. We have a really distinguished panel this year, as we always do, frankly. I'm always impressed with the panels we have here. And this year we have a group of remarkable attorneys and top brass, which we don't always attract here, and seasoned media veterans who will be talking about what's a very hot topic, not only here in our own state, but across the United States, and that is police, ... This panel is going to be moderated by a very dear friend of this committee, Judge Robert Lasnik. He is a U.S. District Court judge here in the Western District. He's been a leader in both the state and the federal judiciary for over 25 years, first in the King County Superior Court and then in the Western District of Washington. He was appointed to the Western District by Bill Clinton in 1998, and he served as the Chief Judge of the Western District from 2004 until 2011, so he has quite a long run in leadership. In addition, he's now active at the national level in terms of representing the Ninth Circuit on their governance body, which is chaired by Chief Justice John Roberts. So someday we'll get him alone in a room and have him tell us everything that there is to know about our illustrious Chief Justice. Of course, he won't tell us a thing. He's also served on many, many committees in the federal judiciary, including the committee that was just introduced here. He has served as the conference chair in 2007, and from 2007 to 2009, he served on the circuit's governing judicial council. As a Superior Court judge in King County, he was the assistant presiding judge and also lent his talents in other ways, including being the chair of the Sentencing Guidelines Committee when that was just a little bit better funded, and also served as the chair of our Fire Brigade Committee. So he is really a veteran in this world. He graduated from Brandeis University with a degree in psychology and sociology, and then later had not just one master's, but two masters from Northwest University in journalism and counseling. So he really is a valuable asset for this committee as well. He then graduated from the Washington School of Law and has been an instructor there on interviewing and counseling for attorneys. He's got many, many awards to his name, too many to go into, and he says, please don't, so I'm not going to. But I would very much like, at this time, to welcome Judge Lasnik to introduce our panel.
Well, my panel, come on up. I'm going to have Jenny Durkan here. She's an attorney at Quinn Emanuel, and before that at Schrader Goldmark and Law Office of Jenny Durkan, and she did something else between that I can't quite remember right now. Oh yes, that's right. She was the United States Attorney for the Western District of Washington. Next to her is Steve Miletich from the Seattle Times, although I still think of him as the Bellevue Journal-American reporter he was when I first met him. Yes, and Monique Ming Laven, she's a University of California Berkeley Bear, and she's a KRO TV anchor and reporter. We have Brian Maxey next to her. He is both the Chief Operating Officer of the Seattle Police Department, the highest civilian officer or person in the department, and a special city attorney, because City Attorney Pete Holmes designates him as such in there. I asked if he got 3 salaries like the Teamster guys do, but he just gets 1. Next to Brian is Ann Bremner, who we've seen before. She's now in charge of the Ann Bremner Law Firm that Ted Buck works at, according to his name tag. Not true, but what the heck, they've always been associated with each other. And Ann does, in addition to defending police officers, former King County Deputy Prosecutor, you see her many times on different television shows representing the law in many different areas. And some of you may not know the gentleman next to Ann. This is George Trejo, and George is an attorney over in Eastern Washington, and he is somebody who handles predominantly United States criminal work, both in Eastern District and Western District of Washington and throughout the United States, and mostly large and very complex drug trafficking cases. But he's also handling the shooting of Mr. Zambrano in Pasco and the shooting of, not the shooting, but the skateboard attack of the Olympia teenagers down in Olympia that got a lot of attention. And because he's never been here before, he brought his posse with him. His sister, who's an attorney in Burien, Georgia, and his 2 boys, who are the ones you thought were U.S. Marshals here to protect me, George and Marcos over there at the table. So it's great to have such a distinguished group of people who are willing to volunteer to do this. So we're going to start with a couple of videos, and then we're going to ask the panel some questions.
Breaking news, that new video in that police take down the mistaken identity. The moment we have not seen before. The famous sports star tackled by an officer, slammed to the ground and handcuffed. Police say it was all a mistake. The new images come just after New York City's top cop was forced to apologize, and ABC's Gio Benitez leading us off.
Tennis champ James Blake standing outside his New York City hotel when a plainclothes officer rushes up to him and tackles him. The NYPD releasing this surveillance video tonight that then shows the officer kneeling on top of him as he handcuffs him. People walking by. After about 40 seconds, he's led away. Blake, once one of the world's top tennis players, telling our Robin Roberts about that incident.
He picked me up and body slammed me and put me on the ground and told me to turn over and shut my mouth and put the cuffs on me.
That officer, James Frascatori. ABC News learning he has had 4 misconduct complaints against him, but an official says only 1 was partially substantiated.
I said, look, officer, I'm scared. So if I say something wrong, I'm sorry, but I want to know what's going on. I think you have the wrong person.
The NYPD saying the incident stems from a case of mistaken identity in a credit card fraud investigation. Police say Blake looked like this man, seen on TMZ Sports. That man also turned out to be innocent, wrongly identified in that same investigation.
If you see those 2 photos together, the similarities are remarkable.
New York City's police commissioner and mayor both personally apologizing for the incident, saying those errors are being investigated. And David, tonight Blake tells us what happened to him is not uncommon, and he is determined to use his voice as a catalyst for change in the relationship between police and the public, David.
Gio Benitez tonight. Gio, thanks.
When police shoot and kill somebody, it's a huge deal.
Power to the people.
We're talking about life and death issues here.
When you're talking about officers' use of deadly force,
Split-second decisions have to be made.
split-second decisions, you have to show that there was malice and a lack of good faith.
It's a standard that says to a police officer, you will virtually never be charged for shooting a suspect.
Hey, put the knife down. Put the knife down.
It's a license to kill.
Thank you. The first video, obviously, James Blake outside the Grand Hyatt near Grand Central Station in New York City. And the second one from the Seattle Times, a wonderful report that Mike Carter, Steve Miletich, Jim Neff, many others worked on, probably going to be a Pulitzer Prize nominee, and raised very interesting issues that we're going to talk about today. But notice on the first video that it was NYPD that released the video. How important, Monique, for your covering a story like that, was it to have the video? Would it have been the lead story on the national news without the video?
No.
Wouldn't have even been a story, right?
Oh, it would have been a story given the athlete involved. And he's so well-spoken that just even made it more of a story, I think. But at least for what we are bound by in our medium, yeah, the video changes everything for us. I would also want to note on that story that when it was first, I'm not sure exactly of the sequence of events, but the story came out and it took a while before they released the picture of the original suspect. And I will just say that my reaction in watching that, I actually felt, it felt more understandable to me, seeing it with more information included than when it started to trickle out piece by piece.
And when you say more understandable, because he looked like the suspect.
Yes.
But even if he was the suspect, should he have been thrown to the ground like that?
That's a different question. And there's a lot of context to it and the situation that the police officer said he was in and all of that. But
now you sound like Ann Bremner.
sorry. But I'm just pointing out that when it came out bit by bit, the temptation, I think, for many people was when they heard of the case and this police officer is saying, well, I mistook him for another black suspect, that you do kind of go, oh boy, what are we dealing with here? So I just put that.
Sure. And Brian, you're the one, when an incident like this happens, they're probably going to come to you as a lawyer and as a liaison with Pete Holmes' office and say, do we have to release this? Yes or no? And if we don't have to, should we release it? How would you handle that in your discussions with the police chief, the city attorney, and maybe even the mayor?
So that's not actually the internal conversation that occurs at the Seattle Police Department. Right now, when we have a critical incident, an officer-involved shooting, the goal is to get out as much objective information as we can in as fast a method as we can. So for the last few officer-involved shootings, that same day or the next day, the video, photographs, the general narrative in an objective sense is put out. We're slightly restrained because we don't want the chief getting out ahead of all of the investigative tools that we have at the Seattle Police Department to review each and every use of force. So she has to respect the due process, respect that the investigations need to go forward, but we want to give as much information out to inform the public as possible. The only times when we don't release information immediately is if there's something that's highly offensive to a reasonable person. So, for example, the end of an officer-involved shooting, sometimes we will blur that or cut it and just have the audio play. The other time would be when there is an investigation, a criminal investigation, not an administrative one, into the incident that has already started. At that point, we would work with the prosecutor's office, whether it's Pete's office, whether it's the King County prosecutor, the federal government, to work with them to see whether that's going to jeopardize their investigation.
Has that always been SPD's policy in the times that you've been working, not just for them, but defending cases in the city attorney's office?
No, I think there's been an evolution, and certainly the department is trending towards as much transparency as it can. And I would say that's really occurred over the last 5 years, really pushing towards working on developing public trust through transparency, and that's.
And Ann, when you hear the police department talk about transparency and getting things out quickly, that raises some red flags for you if you're going to be representing that officer.
Exactly, Your Honor. And an example I think that we talked about before is, remember the sheriff's deputy in the holding cell with the 15-year-old girl? I don't know if people remember that, but it was incendiary. And it was a criminal investigation, and we, of course, appeared in front of a judge asking that the video, for obvious reasons, including due process concerns, not be released, and lost that battle, and it went viral. Well, it not only went viral, but it caught the attention of someone named Christopher Monford, who fixated on that case. And of course, you can't say there's true causation in these cases, but he surely was somebody that reacted, left notes about that case, on SPD vehicles, etc., and then ended up taking a life. And so you look at a case like that, and it wasn't just incendiary to the public. It was incendiary to somebody in the public that really was dangerous. The officer had 3 trials, 3 hung juries. But these are considerations for these officers. I always say there's nothing in nature that can be sliced so thin that it doesn't have 2 sides. But as you go in the court of public opinion versus a court of law, those are 2 very different things at times. And of course, we're in this case.
And George, sometimes it's a hotel security video, sometimes it's a dash cam or a lapel camera, but sometimes it's a cell phone. And a citizen, you've had some experience in the Zambrano case of talking to a citizen who had pretty good video, and what happened to that individual from the cops?
Well, that individual was tracked down by the officers and harassed at home, threatened that force and threatened that charges were going to be brought against him if he didn't immediately turn over the video. He didn't know what to do, so instead of facing any one of those things, he gave them the video. Reluctantly, but he did. And there's, in that light, since the video has already been in police custody, there's no reason for them to maintain that and keep it from the public, keep it from the victim's family.
So you're a proponent for, no matter how inflammatory the video is, it shows what really happened. Let's get it out there as soon as possible.
That's correct, because the inflammatory nature of the incident has already taken place. In these types of cases, a life has been taken, or, for example, in Olympia, there is no video, but had there been one of the shooting itself, an individual was paralyzed. The family of the victims are entitled to see what happened.
Now, Steve, what if somebody came to you and said, I've actually got a video, because the dash cam and the lapel only shows the beginning, sort of like the woodcutter. If somebody had come to you and said, I've got what happened after the dash cam doesn't show it, where you just hear the sounds, then it's a homeless person, but they're not your average homeless person. They're a person who's homeless but used to work at Washington Mutual and did bad mortgage loans before they got fired. And they say to you, I would like $5,000 for the video. Would you pay?
I think that would be counter to the policy at the Seattle Times. We don't pay for information. It just raises too many questions about the motivations and credibility of the information. We would look at it. We would try to convince the person to turn it into us, but I don't think we would pay for it. I would just like to also address Ann's comment about due process in that issue of the videotape in the jail cell. I think it's pretty well established in Washington State and in the federal courts here that you can get a fair trial even in highly profiled cases. It's always been humbling to me to sit in on jury questioning in a really high profile case where they ask a room full of prospective jurors, how many of you are aware of this particular case? And 5 or 6 hands out of 100 or so go up, and which is fully understandable. People have busy lives. They're not focusing like we are on every word as much as we think people are, reading every word that we write. They don't have time or they don't remember it all. So I think that's the reason this video, was made public, is because we have well-established law here that you can get a fair trial despite a lot of publicity.
So, Ann, you've tried cases where there was tremendous amount of publicity, both in the prosecutor's office and in civil cases. Isn't Steve right? I mean, the trial judge picks a jury very carefully. The jurors don't really fixate as much as somebody like this Monfort character did, and we can never predict what crazy people are going to do. But shouldn't we be more transparent in these areas?
Well, but then you take a look, Your Honor, at the question when you look at constraints on prosecutors and what they can say and not say and release and not release before trial. And it's the same kind of issue. I mean, can they go out and say, he confessed, He's guilty. He's the one. I mean, prosecutors don't do that, and it can't do that. I mean, you and I were in the office together. You were a lot smarter, and you were my boss, but I'm
But
just
you were
saying,
a lot younger.
Yeah, that's right. But I'm just saying, you know, it's,
I remember saying to you, you can't do that many times. Sometimes you actually listened to me.
I did. But I'm just saying is that we have to balance those types of things, and a lot of times jurors won't tell you what they've read or what they think. I always ask jurors on a written questionnaire to write down everything they heard about the case or know about it, because you can see where they're coming from when they describe it.
And George, you're shaking your head.
But yeah, I don't agree that prosecutors hold back and don't tell the public things that they know and things that are inflammatory. For example, in the Zambrano case in Pasco, they came out with information that he was under the influence of drugs, that he had a history of violence in his past, and a lot of damaging evidence against him before his attorneys even had anything.
It's sort of like what happened with Michael Brown in Ferguson, where you try to change the dynamic from the police officer to the victim being a criminal or a thug or something like that. Jenny, do you want to step in and talk about what kind of constraints prosecutors feel about releasing video or other evidence while there's an ongoing criminal investigation?
It's always, I think that there's a balance that has to be struck, because on the one hand, I think that Steve is absolutely right that we have to trust the public to have information. We live in a society where I think democracy is protected by more information, more transparency, and knowing what government officials do, and that includes police. So we have to trust the public to know, and it's not the video that's inflammatory, it's the action that a video depicts. Now, obviously the video itself captures in a way, as Monique says, that is different than a description just in the Seattle Times print section or online. Pictures and video are very different and very much more powerful. I think prosecutors have a special obligation that they want to make sure that they try a case within the evidence and don't do anything to inflame a jury one way or the other, and make sure that really due process can be held. I think that's a very different obligation than the press has. And so I think that there's always going to be that balance. But I also think, and I think we're going to talk about it later, there's a different analysis, I think, that occurs, you know, at different stages of a prosecution, particularly when you decline a prosecution, how much can you say about that prosecution?
Right, and you know, right now, or yesterday in Chicago and in Illinois, the Illinois Attorney General was arguing before the Supreme Court for the release of certain police videos. And I kind of laughed when I heard on the James Blake thing that the officer had 4 complaints against him, one of which had been sustained. The guys in Chicago who were the subject of this had over 70 complaints filed against them, and not a single one was sustained. And they were for using racial epithets and all sorts of things. And let me go out and ask Kelly Sager, our wonderful media lawyer from Davis Wright. And Kelly, you just stand up and belt it, and we got a microphone coming your way in just a second. There we go, thank you. Different parts of the country have different attitudes. Of course, Seattle is going to tend towards releasing things, but what's happening in other parts of the country, and what have you been involved in to try to get videos and other things released in cases like this?
Until the mic is, I think I can talk loudly enough so people can hear me. In California, we've had fights for many years to get information about police conduct, including a 5-year fight that we brought on behalf of the LA Times to get the names of police officers who shoot and kill people. Now that may sound like something that everybody would ultimately learn, but the police union took the position that the Public Records Act does not allow the public to know the names of officers who kill people, because that's protected by rules that protect disciplinary records. And for 5 years we fought that battle until it went up to the California Supreme Court, and the Supreme Court ruled that that information is absolutely a matter of public record and the public gets that information. Had it been a small newspaper, had it been a website that didn't have the resources to fight that fight, even though the Public Records Act provides that you get that information, if you win, you get your attorney's fees back, most organizations don't have the resources to fight those battles. And yet we've had case after case where, and not to impugn the police in particular, but the police in California, the unions have taken the position that the public's not entitled to information about what they do. And we're having fights now about videos, release of videos, including one recently where the city of Gardena fought us to get the release of a police video where one young man was shot and killed and 2 others were shot and wounded. And the video was the subject of a multi-million-dollar settlement by the city, yet they took the position that it should remain under seal. And a federal district judge disagreed and released the video. They now have appealed to the Ninth Circuit, even though the video's already out and it's been on websites, taking the position that in future cases those information should not be released.
Yes, please, Jenny.
It's interesting you say that about California. Yesterday I was on the phone with a family who is the wife of a friend's brother was killed in San Diego. Very tragic shooting. Turned out he was unarmed. And the police did not activate. He had body cam on, didn't activate it, but there was a nearby business that captured it. They took that video from the business, immediately told the business they could not release it to anybody else, put a protective order in place, and the basis for the protective order was the video is inflammatory and will endanger police and their view of police. I think it was also done to protect the local DA so there wouldn't be public momentum before she'd made her charging decision, which was not to charge. But I think that kind of standard is something that is not good for our society.
Okay, Monique?
Yeah, I just want to add something into this that, you know, I'm coming from more of a public perception perspective than the legal ins and outs. But I think it's incorrect to believe that where there is a question, there is then neutrality on the part of the public. If they haven't seen the video, they will fill in that void on their own. And I think that Ferguson's a perfect example for that. I mean, without video, you still have people deciding what happened. And I think that sometimes video can clarify that, maybe not in the way you would want it to, but it does cut down on the question.
Brian, internally, and we have your boss, Pete Holmes, here too. Was there resistance from the brass or from the union? Did you hear pushback about this shift towards more transparency?
Well, I mean, it's been an evolution, and a lot of the recent public disclosure court decisions have really clarified the parameters of this. Previously, we were interpreting the Public Disclosure Act to allow us to, in fact, require us to withhold videos in certain circumstances. That was clarified, and previously, videos had been given out for certain circumstances, snippets played in the press, and we felt that we actually could not affirmatively put that information out, which may have given the context and the whole story, and in our minds, you know, skewed the narrative. Now, we're trying to take advantage of the openness and to tell our story as soon as possible in as objective way without compromising all the process. So there certainly have been different choke points along the way where people have resisted and rebelled against these concepts, but generally there's a culture shift at the department where people are understanding it. I think recently I heard an officer say out on Nextdoor on the social media, Diane Newstrom responded, "I know I have given up my privacy when I put on the badge." Now I think that's a scary sentiment because it's not true, but certainly it reflects a changing culture shift.
And Steve, you've seen FBI Director Comey kind of blame this focus on police and video for making crime rates go up because officers are kind of reluctant to put themselves in not just harm's way, but now it's harm's way and a video camera's way. Did you have a reaction when you read that?
Well, a lot of it seemed to be anecdotal, and I think he's backed off a little bit since then and acknowledged that it was anecdotal, and others have supported that. And what has happened, I think, is this issue has broken down to extremes. Is it causing police officers to be attacked, killed in some instances? Yes, that's happened, but the statistics show that attacks on police officers are actually down in recent years. On the other end, we have shootings in the minority community or other places where they're all bad. So we've got this polarization going on. And I think our job in the media is to step back and look at each situation and the facts and try to sort it out. That's what our job is. And I think the ultimate reading on this is that police safety and police accountability are not necessarily mutually exclusive, that you can have both by dealing with both. And I think that's at the heart of the consent decree we have here in Seattle, is that the idea is that police officers and the community are safer when they work together. And so the challenge for us is to take the heat down a little bit and try to shed some light on these situations.
And Jenny, you know what it was like dealing with the FBI and the issue of whether they would allow even a statement from a suspect to be taped, audio taped, let alone videotaped. And that took decades to turn them around, and really at the highest levels before they would finally agree to it. Isn't there just that's not the way we do things in the federal law enforcement community?
I think there is. Now, I think that there's the way people do things usually starts with a good and principled reason. And I think what happens is things evolve, and so making sure that you've evolved with the facts and you hold on to those things that still are basic and fundamental fairness issues, but evolve so that you can really serve the times. I mean, people just communicate differently now. They digest information differently. They look at news differently. You know, I look at my younger son, and he will be online playing a game, chatting in the game, Skyping with someone else, doing something else, clicking between screens to look at what's going on his, Twitter feed. And it's just a very different way of processing information, and I think we have an obligation as a society to make sure that we're thinking about how do we have information that is fair and factual, but that the public deserves to know.
And is that before or after he reads the Seattle Times?
Right.
Yeah.
First thing in the morning,
Yeah.
Seattle Times.
Steve, the piece that you worked on with your colleagues was really a wonderful look at the state system, but it didn't really emphasize in the difference between state and federal, between criminal responsibility and civil liability. Did you think about doing a broader look at the full picture there?
Looking at civil liability?
Civil liability, and also looking at, maybe the state prosecutors have limitations under that statute, but what about the feds when they look at things?
Well, we had two discussions in trying to decide the parameters of this, and one was, do you go deep into what the federal role is? And that is such a separate subject and so involved that we touched on it with the AutoZem case in Eastern Washington and how the federal government got involved.
Where the officer was convicted.
Right. But we didn't go into a deep analysis of the legal standards. The other issue that we discussed, in particular with Dan Satterberg, was whether the civil system provides a remedy. And again, that would have been a separate tangent that would have taken us away from our main focus. But we did talk about that. I think Dan took the position that the civil remedies, maybe even more than a criminal prosecution, get the attention of government. You have to pay out money. There's the spotlight on the trial or the settlement that results in these cases. He takes that position. I think others take the position that a criminal prosecution is what really the average person pays attention to. So we were aware of those issues, but we really wanted to stick to our main focus, which was on this state law and the findings that we did from our in our database. And
George, let me ask you, because you've brought civil damages cases in both jurisdictions, Thurston County and over in Pasco. You were very disappointed that the state prosecutor did not bring criminal charges in the Zambrano shooting against the police officers. Has the U.S. Attorney's Office finished their investigation and announced anything? Or really are you looking towards a civil trial here?
I'm pretty much looking for the civil trial. Very disappointed in the manner in which the investigation was handled over in Franklin County. The duration that it took them to look into the case was ridiculous.
How long was it, like 7 months or something like that?
I mean, Mr. Zambrano was shot and killed on February 10th. The report, the investigation, was completed the end of June, and the prosecutor didn't make his decision until September the 8th, and yet it's still going to continue to linger on because the county coroner over there, despite the fact that the prosecutor already made his decision, is still going to conduct an inquest in February.
Right, and that inquest procedure varies county to county. We have former Chief Presiding Judge of the King County District Court, Barb Lindy, here. And Barb, tell us about King County's kind of unique coroner system.
Thank you. In our county, there's an executive order that provides for an inquest. In some counties, as I understand it, there are coroner's inquests. Sometimes a prosecuting attorney conducts an inquest. But in King County, the executive, when there is an officer involved, basically a death at the hands of a law enforcement officer, the executive gets a request or some information from the prosecutor, and the executive then makes a decision about whether to convene an inquest and asks the presiding judge of the district court to appoint a judge to hear it. There was one occasion when there was a special request, and I don't remember the details, to have a Superior Court judge hear it.
That was Mel Miller. It was Pat Clark.
Oh. That's
And
right.
then but it's also unusual about the King County inquest is you have the prosecutor sort of performing more of a, almost like presenting evidence to a grand jury. You have the police officer having an attorney there, and the victim's family having an attorney there, correct?
That's correct.
And a 6-person jury, is it?
It's a 6-person jury.
And they just come out with a, was it a justified shooting, yes or no type verdict?
They really make a factual determination, that sounds a little bit like a legal conclusion.
I see,
They make
yeah.
a factual determination about whether the officer feared for his or her life, whether, basically what happened factually. It's not without controversy, this process. It is very frustratingly devoid of those kinds of determinations. And so you get just the facts, and without drawing the conclusions, the public gets to see into the investigation somewhat, but without really probably the most important conclusions that the public's interested in.
And the prosecutor is not bound by the inquest jury's decisions one way or another.
Correct.
And you've sat at some of those inquests.
Many.
As the representative of the police officer who is the shooter. Tell us what your impressions are about how that process works.
Yeah, I've had scores, 30 or 40 of them, Bellevue Police, King County, Seattle, many of these, because we have them every time there's an officer involved, death, shooting, et cetera, in this county. And I do some coverage for CNN I did it on Zimmerman and Ferguson, and what I've always said is, people were so upset in Ferguson, I just want to preface my remarks with that, because there was no transparency, but we have an inquest process here that happens relatively quickly, and it's a who, what, where, when, how. It's factual, televised, open to the public, and as Judge Lindy described, the parties are all represented, and the prosecutor presents the evidence, and it's presided over by a judge. It doesn't get much better than that in terms of putting evidence and information out for the public. And when you're looking at Ferguson, that was a grand jury proceeding, and that was a long grand jury proceeding. And so no one knew anything really about the facts, and you get a lot of misinformation. I mean, if we're really looking at making sure people have full information, let's do it the way we do it here in King County. And I've always said, it's a real model, I think nationally. You just don't see it all that often in these huge, controversial police death cases.
And George, do you have any understanding of how the coroner inquest is going to be in terms of whether it's a public versus closed hearing, and whether there will be an attorney there for the family and for the officer?
It'll be a public hearing. They've already set it for some big arena where the hockey team plays over in Kennewick. And
Between periods, or?
And somebody be selling beer. But the only person over there, under their rules, that is entitled to ask questions is the prosecuting attorney, which will make this one very interesting, because the prosecuting attorney doesn't want to have the inquest.
Right.
And if
He's already made his decision that it was a justified shooting.
And the only thing that the family's attorney can do is scribble some questions down, pass them up to the coroner.
Yes.
And the coroner will say, I don't like this question, I'm not gonna ask it.
Sounds like federal court. So, and then the coroner makes the decision himself in whatever way he wants to.
Yeah, a recommendation. And that's all it is, a recommendation that does not bind the prosecutor.
So is that something you're looking forward to, or is it something that you're thinking, sounds like the deck's already stacked against me?
I think it's a waste of time.
Okay.
The information and evidence that will be presented to the coroner is already been made public. You go to the Franklin County website and all the witness statements are there. All the police reports are there. There's nothing outside of what's there that will be presented as new evidence. So what's the purpose?
And Jenny, we've seen in the Seattle Times report and all over the country, local prosecutors who are elected decline to file these cases. And then there's an announcement that the victim's family is disappointed. They're looking to the Department of Justice to bring justice to this situation. And again, we don't have all lawyers in here. So tell us about the difference between state and federal and criminal, what charges you could bring as opposed to what the state prosecutors can bring, and how do you wait till the prosecutor declines a case? Do you start sooner when you know it's a case that has implications of civil rights or racial discrimination? Tell us about the U.S. Attorney's role.
That's great. Well, historically, when the Civil Rights Division was created in the Department of Justice, they originally had exclusive jurisdiction over civil rights cases. And people remember in the 60s, there would be parts of the country that felt that there would not be the ability to get fair trial for police misconduct. The typical model was the Civil Rights Division then, after there was either an acquittal or a decision not to charge, they would conduct their own investigation and sometimes their own trial. In our lifetimes, a very concrete example of that is Rodney King. After he was acquitted, the Department of Justice investigated and prosecuted the police officers and charged them. U.S. Attorney's offices have to get buy-in from Maine Justice before they can bring any civil rights criminal case. And in a civil rights criminal case, the burden actually is even higher than the one that was described on this video. You basically have to prove a willful deprivation of civil rights, that the police officer at the time they took the actions, whether it was physical force or shooting, the ultimate force, that they intended to willfully deprive someone of their civil rights. One of the things I tried to change coming in, where there's about 3 different things that I think locally you can have an impact on. First is to establish that relationship with the Department of Justice so that you actually are the initial gatekeeper and it's not someone who's distant in DC that doesn't have a stake in the community. The second is you can imagine there is a day-to-day working relationship between state, local, and federal law enforcement. They work together shoulder to shoulder on a lot of issues.
A lot of task forces, too.
A lot of task forces, that's right. It's very difficult for the FBI to step in and investigate the police officers they know. You combine that with the deference for local prosecutions, which we can talk about a little bit, which is very appropriate in many regards, is to let the state and locals do their own law enforcement first and the feds not step in every time. But there's sometimes when there's a federal interest, like civil rights, that has to be vindicated. I think that when you start that FBI investigation is very important, because if you wait until the state investigation is completed, you are left with their sandbox. And you're left with the witness statements that are created, the crime scene is all theirs, and so I think we tried to urge as early as possible for the FBI to get involved and do their own parallel investigation. The next step you do, of course, is can you charge or not charge? As people in the room may or may not know, in the federal system, criminal cases are presented to a grand jury, and there's a strict rule that keeps the proceedings of the grand jury secret. And its intended purposes is for a very good reason. It's protect the people who are being investigated so that their name isn't besmirched in the community, and you aren't doing exactly what George has said, is leaking all the harmful stuff, drip, drip, drip. So you have the investigation, but if you then decide that you're not going to charge, the normal case is you just don't charge. You don't make any public statement, you don't do anything. We ran right up against that in a couple of cases of public interest. One was the WAMU case, which wasn't a public shooting. One was in the Ian Burke case. Dan Satterberg had already declined. The family then, as Judge Lasnik says, turns to us and says, you know, are you going to charge him? And so then we have to go through our own investigation, our own analysis on whether he meets it. I made the determination that we could not meet the burden of proof in consultation with my colleagues at the Department of Justice. The normal procedure.
This
then
was
would
the
be
woodcutter, the Indian woodcutter case.
Which
Ian
was
Burke.
the case. The normal procedure then would be, in a federal criminal case, is you just don't charge. You're done. You don't say you're not charging. It's done. There's such public interest in these cases, and it's so important to have public confidence in both our system of justice, what we're doing, and we're looking at things fairly, in the victim's family or the subject who's been killed family, and I think in the police officers and community to know why you make a decision. So in that case, we made the decision that the Department of Justice top brass flew out. We met with the family, we met with people in the community, we met with police officers, we went with union reps before we made our public announcement. But we thought it was really important that, unlike in other cases where you just make a charging decision but you don't announce anything, in this arena, particularly at this time in our nation's history, it is, I think that confidence in the judicial system and confidence in the police demands that you give more of an explanation.
And so you actually had a news conference where you announced it?
We had a press release, and then I think pesky people like Mike Carter called me up. And,
okay.
And we don't go into, there's some things we can't say. You can't talk about what's going on with the grand jury, but you can tell people what the standard is, why you reached your decision, and make more of an explanation so that people know it wasn't just a rubber stamp.
But did you actually convene a grand jury and present evidence to the grand jury, or did you just make the decision yourself?
The normal course in those things would be to have a grand jury.
All secret.
You've never followed the normal course in general. Did you follow it in this one?
That's right. There would always in these cases be a grand jury investigation done at some level and information be presented to the grand jury, but ultimately we have to, the prosecutor, the U.S. Attorney, and the Department of Justice have to make the decision, do we have enough evidence that we could meet the burden beyond a reasonable doubt? And if we don't, we make the decision not to present that ultimate conclusion, and that was my decision.
Not to present that ultimate conclusion to the grand jury.
Well,
yeah. It's a little more complex
Okay.
than that, but yeah, the decision not to charge was made, but we didn't just let it go. You know, I think in that case and other cases, the same. We did a similar thing in the WAMU case. There was a decision that we could not meet the burden of proof to charge people in WAMU. It began before my time. There was some impetus on some people to let's just walk away. I think Emily Langley, who's here, was one who advocated, look, we can't announce a case and then not tell the public what resolution we've reached and why we reached it. And I think that is sometimes the case.
We haven't really spoken that much about civil liability, and I want to talk a little bit about that. Brian, when that woodcutter case is declined for criminal prosecution in state and federal court, how do you and Pete Holmes and the city decide what they're going to do with the civil lawsuit? That's not a case you necessarily want to take to trial, right?
No, and that one actually was a pretty unique circumstance because in that one we actually had the Seattle Police Department that was coming to the conclusion this was not within policy and they were not going to support that, which leads to a lot of conflicts and a lot of different analyses that go on. In that particular case, the city made the decision to reach out to the potential litigants and the attorneys and go straight into mediation on it and figure out whether we could have an early resolution on that case rather than having further protracted civil litigation around that. And ultimately that was successful.
And Monique, every day it seems like I pick up the Seattle Times and on my way to the sports section I see a Mike Carter story about Linwood cops, Linwood settles for $60,000 because the cops did this horrible thing, or a lawsuit's been filed against Seattle police officers for the horrible things they did. And then there's a story about it's the trial, if it goes to trial, and the verdict and the like. But it seems to me I never see that in broadcast journalism. Is that a story that just doesn't have enough visual for broadcast journalism, the civil liability?
Well, it takes a lot of following up on a case and a lot of dedication to it. Without a visual, it's tougher for us, but media, as we all know up here, is definitely changing. Nobody's just a print or broadcast journalist anymore. There's a home for information for all of us. So it is a matter, we probably report that, it's probably on our website, but you may not hear it come out of my mouth.
Got it. And just like that, the Seattle Times uses video in ways they never have done before. So Brian and Ann, you defended police through many civil trials.
Right.
And you know that, I think I've done probably 15 or 20 cases that actually went to trial, and not a single one was a plaintiff's verdict. They're tough cases for plaintiffs to win.
I don't know if you want to start, Brian. I mean, I always say I've defended the police. I don't want to say how old I am, but decades, police officers. And on liability, Your Honor, I've never had a liability verdict against me with juries, and I've tried a lot of them. Now, that says we have great officers, in my mind. It doesn't say I'm the greatest trial lawyer out there. Juries over and over and over again find for the officers. And I think one thing I think needs to be said here is officers have civil rights too. They've got a right to a fair trial too. And I disagree with Steve. I encounter juries all the time in my police cases, whether it's Portland Police or up here in the county or whatever, where they've heard about these cases and they have opinions about these cases. I mean, people pay attention.
Well, they certainly know now about Ferguson and maybe Eric
Right.
Garner and a couple of other
that's right, Your Honor,
cases.
but I think there's just more of that awareness. But I also think that in these civil cases involving the police, we're talking about two very different things. And one is the media and public perception. And the other is really, is there a rush to judgment in a lot of these cases, in civil and criminal cases with police? They're two very different things.
And I want to ask, go ahead, Jenny.
I think that's right, Ann, but I think there's a difference between legal liability judgment, whether it's criminal liability or civil liability, and a general public sense that something's wrong or not right. Someone can do something that the general sense of the public is, we don't want that activity. And it still does not reach the level of civil or criminal liability. So I think that I don't think we should confuse those things. I think that what your record shows, and I think even what the hung jury in the civil rights case of the person in the cell showed is, juries can put to the side their emotions and follow instructions. I think we have very good and probably conservative juries in the Pacific Northwest. And so I think that is a reflection more of, do you meet a legal standard, not necessarily should we as a society comport ourselves in a different way.
The only thing I was going to say, and I understand those sentiments, but where I was going with this is that when we've got the press and free press, and like Jefferson said to Lafayette, the agitation that it brings, free press, free speech, makes our waters pure. That's a great quote. That's a whole different question than the case itself. How's that case going to go? Because the press doesn't have all the constraints that we have. The press doesn't have all the rules that we follow. The press doesn't have the discovery rules, whether it's criminal or a civil case. And that hung jury was a criminal case against an officer. That's a whole different set of ethics, standards, and views. Then I'm a lawyer. I represent police officers often, and I have a case to defend. So all I'm saying is these are very different things.
But I will say this, Ann. I got to say this because those cases I presided over, if I were the fact finder, I would have found for the plaintiff in at least some of those cases. I mean, some of the behavior is absolutely shocking. And the police get every benefit of the doubt from the jurors, not just in criminal, where you saw how difficult it is to get convictions.
Right.
Well, many of them are acquitted. But on civil cases, too, they know that police officers put themselves and their lives on the line, and they will bend over backwards to give them every break.
And Your Honor, remember the one that we had in front of you, Ted Buck and I did. There was a summary judgment granted against us before we tried the case. We tried it on damages. It wasn't a liability to the jury, but that's probably one I think you're thinking about.
I was actually thinking about the one John Henry did the criminal case on, and the jurors in the
he defended
felony case, they acquitted the the individual and went down and said, you should file a lawsuit against these police. What they did was outrageous. Now, they did file a lawsuit. Unfortunately, they went and got a different lawyer instead of John Henry, and who knew better than to take the case, I think, for a lot of reasons.
Smart guy, right?
Yeah. And
in some ways, right?
In some ways, yeah. And then, you know, I was astounded, you know, at the verdict. So that's the one I was thinking about. And this is a police officer, an SPD officer who has since been fired for other reasons. So, you know, what goes around sometimes does come around. Brian, you've defended also, and you've also settled many cases where you looked at it and said, even if there hadn't been a finding by the review board or by the brass, this just isn't something we should take in front of a jury, right?
Yeah, I mean, the major driver in these civil rights cases in terms of risk analysis really comes down to the attorney's fees. So in those cases, the classic lawful but awful cases, right? Did we have probable cause? Yeah. Was it the right thing to do? A jury might not agree with that. So there's certain risks that play out in all this. And, you know, my experience, I certainly haven't done as many trials as Ann, but
you're just not as old as I am.
You know, in the last 10 years, there have been 2 adverse jury verdicts in civil cases against the Seattle Police Department. Both of those resulted in a jury saying $0 in damages.
Right.
So these were juries that were acting on a principle. They weren't trying to award money to the plaintiff. They were actually flagging that they felt something wrong had happened, but they weren't going to award the plaintiff money for it. And so that pushes back a little bit against you're always going to have a plaintiff's verdict. These things are a little more nuanced than that.
You know, and I think part of it is, I mean, to put in context, police officers do have a very difficult job. And they are put in positions that they have to make choices that most of us never have to make. And we don't want them hesitating at that moment where the right decision will protect us. And I think because of that, we have constructed a legal system that gives them the benefit of a doubt in many ways. You know, if you look at when a police officer shoots someone, if you had a civilian shoot someone in those same circumstances, that civilian would be arrested, they would be taken down, they'd be immediately questioned. If they invoked their rights, they'd be given a lawyer. Police officers, it's different. They're allowed to consult with a union rep. I won't use this state as an example, but in the case I was talking about in San Diego, they take the officer away. They give them a certain period of time, usually 24, 48, 72 hours before they even start to question them. During that period of time, they can look at witness statements, videos, and the like, and then they're allowed to give their rendition of what happens. We do that because we have decided as a society that we want to protect police officers, give them the benefit of doubt, and allow them to protect us. But it does create a system that is not the same as if there was those same activities in a civilian thing. And I think it's appropriate, but I think it is also appropriate for us always to ask the questions, have we tilted that balance in the right way? Or is the law the right, the jury instructions, the process, the procedures? And I think that's where we need to look at those questions.
And there is another element to all this.
Steve?
We've focused on the criminal and the civil, but there's also the administrative. And when all this is over, it goes into that process. Ian Burke resigned knowing he was going to be terminated. Other cases like that had similar results. So there still is this safety valve, or whatever you want to call it, to take another look at it and some satisfaction that there will be an internal review and decision made by the police chief.
Sure. Brian, you want to say something?
Well, yeah, and I think it's exactly jumping off of Steve's point, which is that there are many different systems that are going all at the same time. You've got the administrative review, you got the criminal review, and in Seattle, officers are actually compelled to give a statement the night of a use of force.
That's in the labor contract, right?
No, that's actually as a result of the consent decree.
The consent decree now, okay. Great.
Shifted it so that we have a force investigations team that will roll out for any serious use of force, and that would include officer-involved shootings. Yes, there's an attorney present. Yes, there is a union representative there, but unlike a criminal suspect in a case like that, these officers are generally compelled to give a statement under garrity, which means when you're in that rock and a hard place between your constitutional right not to self-incriminate and the employer's obligation to get information for administrative purposes, you can get a statement, you cannot use it in a criminal proceeding. But officers are, these days, are compelled to do this on the night of the event. It is audio recorded. A representative of the Office of Professional Accountability is also present during that initial interview. There are many different safeguards that are in place, and it is still different than what a civilian would go through in a similar context, but that's because there are a lot of other processes at play too. We're trying to get that balance right.
Well, and one other thing to add on that is when we're looking at the standard, officers have a duty to use force where it's appropriate. It's where it's necessary. You know, protect others, protect themselves, protect the public. And so it's different than a civilian in terms of what that duty is and the ladder of force and so many other considerations. So I think we have to look at that when we look at police officers, there's certain rules that apply to them and certain laws that apply to them because of their jobs.
And George, when Ferguson happened, you know, my kids were going nuts, and I said, the prosecutor's not going to file charges. You know, local prosecutors are under tremendous political pressure. But also, I said, and if they did file charges, there's a 0 chance he's going to be convicted. What, you know, you're clamoring for police to be charged, but we see that when they are charged, even in cases that look fairly clear-cut, you either get an acquittal or you get a hung jury. That doesn't it work against what you're trying to do to have a police officer walk out the door and, you know, be embraced by his chief, like what happened in Everett after he was found not guilty?
Well, I think it's best for the public to see that their elected prosecuting attorney has the intestinal fortitude to file charges against a police officer. There's nothing wrong with that. And then let a jury from the community to decide whether or not that police officer should be held criminally culpable. I mean, Brian made a comment concerning about how it's unfortunate that police officers believe they give up their privacy when they put on the badge. But why shouldn't that be the standard? I mean, police officers are in a group of individuals that have the authority to take a life. No one else in our society has that authority. So they should be held to a different standard.
Okay, and you know, we haven't really talked that much about race, and you can just look around the room and see that African Americans are not represented on the panel or in the audience, but the interactions that have happened in America going back for centuries and up till now seem to run a pattern of white officers using excessive deadly force on black men for the most part. And Ta-Nehisi Coates, who just won the National Book Award for his brilliant book, Between the World and Me, was motivated by the death of his friend at Howard University, who seems that he was killed for no good reason by an officer who was neither disciplined nor charged for what he did. Let's talk about race a little bit. And George, what have you seen about how race operates in these areas?
Well, my view of how race impacts these areas goes beyond race. I see it more of one involving the social economic class of the individual. Because if it's an upper class African American, if it's an upper class Latino, they're not going to be treated the same as someone from the ghetto or the barrio, nor are they going to be treated the same as a poor white person. The poor people in our society are the ones that are getting stepped on the most by police officers, irrespective of their color. The African Americans get the most publicity. And my view of that is because their communities organize quickly and are not afraid to step forward. I've commented over in Franklin County and in other parts how Latinos have a tendency not to do that. They don't become very vocal. They don't burn cars. They don't terrorize communities. And as a result, they're not, they don't get what they ask for as much as African Americans.
Interesting. Monique and Steve, let me ask you from a journalist perspective. You see Eric Garner, Michael Brown, black men who have committed, if any crime, relatively minor crimes, selling the cigarettes like Eric Garner did in Staten Island. Do you talk about how race affects your coverage of police use of force cases? Steve, in your report, did you try to talk about how many victims were African American, how many officers were minority, et cetera, like that, or did you stay away from race in there?
We did in that story. We came to two findings. One, that African Americans, and men in particular, were victims of a disproportionately number of police killings compared to whites and other groups. They were, and then also that unarmed blacks, African Americans, were also at a higher rate. So we did look at that. What we didn't do, because it gets extremely complicated, and I did a fair amount of Google searching for this, is the deeper reason for this. And there really isn't a body of scientific work or sociological work out there on this issue, and it really needs to be done. You know, what is driving it? You know, we can look at, you know, the perceptions when officers arrest people on the street, to the way the court system handles it, to our laws, like the difference between crack cocaine and powder cocaine, how all that plays into it. But it's more anecdotal. It's a big, huge gap in our understanding, and that's probably the next big issue to tackle.
And Monique, because you're a visual medium, you see Eric Garner was described as, he was uncontrollable like an animal. He was a big man. Michael Brown, he came at me like, like a demon. Those kinds of words are used about large African American men. And as Steve said, it's almost assumed that the black man will have a weapon, so I have to use my weapon before he uses his. Do you talk about those things when you're talking about covering crime and reporting crime? Are we being sensitive to those issues?
All the time, and I think that's the great fortune of video, because you can just let it play. Every time that there's a description of a suspect or a police officer and involved incident, we always talk about, is it relevant? The race of the officer, the race of the suspect, how does it help clarify the story? Especially with suspects. If your description, let's say, is a black male in his 20s with jeans and a black jacket, really? I mean, does that narrow it down at all? But so for the recent case with the woman who got punched in the eye by a police officer, it was an African-American police officer, an African-American suspect. And I remember when we got that video, we were so relieved. Honestly.
But I would say, I'm trying to think of what's pending in my office.
It's been resolved.
I know it's been resolved. I would say that in that video, though, I had the same reaction. People saw it. They said, "Well, it's a victim of color, a police officer." I think that police officer was allowed to do things at that scene and say things that if he had been a white officer, he would have been called a racist. He's saying things about your mama and all that. So I think sometimes we give a pass. I want to spool it back.
That's not giving a pass. It's just letting it be what it is on its own, and us not having to interpret what's worth saying and what's worth not.
And what was really fascinating in that case was the one group that stepped forward and made a strong comment was the NAACP here. They said, we don't care about race. The officer should be fired and should be criminally prosecuted, and they publicly criticized the prosecuting attorney for not bringing charges. So I found that fascinating that the NAACP was the only group to step forward and looked at it, in a colorblind way.
One thing that we haven't touched upon is the whole issue of implicit bias, which, is a session can go on forever. But I think we are, we are now realizing, that almost every African American man I know had the talk with his father. What to do when you're pulled over. Hands on the wheel, 5 and 10, polite behavior, and you have a whole generation of young black men, medium-aged black men who have this whole, they expect to be treated in a certain way by 5-0. I mean, you can just shorthand it that way. It's not the best way to do it. But the other side of the thing is, I think where some of the work that you see needs to be done with police officers, particularly in urban areas, is the implicit biases that also build up if you're in that police officer who is the beat that is primarily people of color, where there's also large numbers of shootings, you know, drive-by shooting, you know, victim runs away, described as African-American male. Victim taken to Harborview with gunshot wounds, African-American, and they hear that day in, day out, day out. How do we work with those police officers so that they can translate when they see people, they are not playing that audio tape and that videotape of what their reality is when they're in the squad car by themselves in dark responding to a very dangerous situation. And so I think we have to remember that those realities that both people are feeling are brought to the situation, and if you don't work on both sides of it, I don't think you can bring us closer together.
Yeah, I think that's a great point, Jenny. And you know, Jenny and I had a situation where that really came to a forefront in a criminal case with African American defendants and one potential African American juror. And Jenny knows the story. Her assistants wanted to excuse that juror because he had had a bad run-in with the police before. They stopped him for driving while black, and he didn't, it really bothered him. It happened on multiple occasions. And Jenny's assistants wanted to use that challenge, not because he was African American, but they were going to challenge everyone who had a bad experience with the police officers. And as I pointed out to them, if you do that, you would not have Eric Holder on your jury. You would not have Barack Obama on your jury. You would not have any African-American male who honestly answered that question and had lived in America for any period of time on the jury. And you know, we have a law that says you can't just excuse somebody from a jury just because they're black if you have a racially neutral explanation. And this was a racially neutral explanation because they did dismiss other jurors who had had problems with the police. I could not really award the MADSEN challenge in good conscience. So what I asked is, please go downstairs and talk to your boss and other people and see if you want to do this. And we'll just take the rest of the day off and you let me know in the morning. But if you are going to use that peremptory challenge, you're going to do it in front of all the other jurors. And to their credit, they talked to people, they thought about it. And one of the assistant U.S. attorneys was of Indian descent and was darker than many black men, Aravan. And he said, you know, he'd been racially profiled by New Jersey state troopers. They had a policy of racial profiling, and he agreed that they would leave that juror on. And of course, the jury convicted. There was not a problem. But it's this mindset that we get into that we need to rethink what we're doing at all times. And I give Jenny and her people a lot of credit for taking a nice long look at it and saying, no, we really, you know, we have an obligation not to do that. So appreciate that. And let me ask you, you've said you defended police so many times. How many were women police officers and how many were African American police officers?
You know, I couldn't give you exact numbers, Your Honor, but I've of course represented all. And this has been since I was a prosecutor from '83 to '88, and I started defending police in '88. So
it isn't just white males, is the point.
It's definitely not just white
Right.
males. And the other thing is, in trying these cases, you know, with inquest juries and civil juries and criminal juries, or here in Portland, or you know, other places, you know, and again, I look at the media kind of accounts versus the reality of these cases that I see, and it's my reality, but it's the reality of the cases. And defending them, it's just so different, you know, and it's so frustrating oftentimes. And I just want to say that because so many of these officers, and I've been with them at 2 or 3 in the morning when there's a death involved, you know, they're upset, they cry. You know, I call
And
their families.
oftentimes, after they're found not liable after a civil trial,
Right.
they break down in tears also.
That's right.
And they've not been able to sleep. Their entire lives have been affected. Being sued in federal court and being accused of doing terrible things to an individual and having to explain what you did and why you did it to 12 strangers in a U.S. district courtroom is no fun, is it?
Oh, and the other part of it, Your Honor, it's so well stated, is that it's not just the defense we do of our clients for the trial or in the media, but it's for the rest of their lives. You know, how do they go on from the case? I mean, I believe that's our obligation as lawyers. You know, how do we get them through that firestorm? if it's in the media or if it's not. And that's part of it too, and that's why, even though I do media myself, I can be more critical because I do it myself, I guess, of the media, but these people have to live through these things with their families, their friends, their coworkers, in a courtroom, outside a courtroom.
Right, and George, you should talk about your living with the survivors of the families and how are they deeply affected by what's happened to them?
Oh, emotionally distraught.
Mm-hmm.
And whether it's Olympia, whether it's Pasco, or any case for that matter, on a daily basis, they're just torn up.
Yeah.
It's on all the way around.
Right.
I mean, I understand completely what you're saying. I've seen it.
Pete Holmes, it looks to me like you're the only elected prosecutor in the room. So let me ask you, if I could.
And you're front and center.
You know, you have a unique position in one sense, in that the police union wasn't a big backer of you when you ran against the incumbent, and they were a big backer of him, possibly for some of the reasons why things needed to change and have changed. But when you approached what the city attorney was saying about releasing videos and who they were farming cases to and which ones they were going to keep in-house, tell me how you dealt with that, knowing that you have to run for election, and even in the People's Republic of Seattle, law enforcement can have an impact on an election.
Seattle.
Stand up, let's get,
sure.
Look at the camera, not us. Okay. You're an elected official.
That's what I do. That's what she does.
I almost made a clean break, too. You know, I think first my analysis starts with the charter responsibility that, you know, the city attorney is elected to both defend the city as well as to be the prosecutor. And so, you know, it was a tough decision, particularly on the 1983 cases, that I inherited a situation where an excellent law firm had the situation of defending every civil action brought against police officers. And I thought that that was an abdication of my responsibility to make sure that I not only defended those cases, and believe me, I don't bring cases in-house to lose them, and it was really hard trying to convince the SPOG president that I'm very competitive and I don't bring cases in-house to lose cases. And as Brian said, we've been quite successful. But it was one of those things that was really tough. It was a cultural shift that was required. There were contractual arguments that were made, but at the end of the day, I think that what really happened was an opportunity to say, it's my responsibility to do this. It would have been a lot easier to just to continue shipping these cases out to a law firm and have the chips fall where they will. But instead, we were able to bring in not only excellent lawyers like Brian to handle this work, and develop that expertise, but we were so ready when Jenny and her team came to town to talk with us about a patterns and practices investigation, because a lot of those same lawyers were not only at this point helping me to understand better what the city's role would be, but also the police department, understanding them, understanding their job and educating them about the constitutional standards. So all of that went into it. That's a short narrative about what was really a 3-year ordeal to go through and make this happen. But we're not looking back. It's certainly been wonderful. And now my biggest problem is that my lawyers get rated by the police department rather than basically not listening to us.
You said rated with a D, not rated with a T.
Correct.
Right? Okay. Yeah. All right. Okay. Thank you very much, City Attorney Holmes. And let me ask Mike Carter, because Mike worked on the project for a long time, and with all due respect to Steve, I think Mike's probably seen more police use of force cases than anybody in the room, and you know what I'm talking about. They're very tough cases to win. What are some of your observations? Stand up, face the camera. There you go. You might need a career in broadcast when the paper.
Oh, no,
never mind.
No. He's got a face for Prince.
Yeah.
I don't want that. Yeah, I've been around almost as long as Ann has.
I was going to say.
I cover mostly the civil cases, and you noted that, Your Honor, that while there are very few criminal cases brought in this jurisdiction, we're all aware, but I do see a lot of civil cases, a lot of these 1983 cases, and I understand that they're very, very difficult to bring. The people who bring them are often at a disadvantage. They have to hire a lawyer or find a lawyer that's going to do it for them on a contingency. Some lawyers are better than others, and these cases, the law enforcement officers have tremendous advantages when they do get in the system. They are afforded qualified immunity that is a very high, I mean, you have to do a Fosbury flop over that bar. It is a very, very difficult bar to get over. They're given every benefit of the doubt, in addition to the fact that a lot of them bring what are called Manel claims, trying to show the department's training is somehow responsible, and that's almost impossible to prove. These cases tend to settle, and one thing I've noticed since Brian and Pete have taken over is the city, Stafford Frey, the former firm, fought these cases tooth and nail. The city has seemed like it's been more reasonable in its efforts to settle some of these cases before they have to go to trial. I mean, there have been several big ones. The verdicts, one of the verdicts I think you were talking about was the Rutherford case. It was a $1 verdict that cost the city hundreds and hundreds of thousands of dollars in attorney's fees. I think we're trying to avoid some of that, but the civil arena is very difficult to wind up in, and criminal cases, the individuals don't have to hire lawyers. It's up to the prosecutor's office to do that, and they're hard.
And I just want the other journalists in the room to realize when you have somebody who's not a lawyer but covers these cases, they start sounding like a lawyer, talking about absolute immunity, Manel liability, things like that. But it's very difficult for the media to get their hands around this topic because it's not a simple topic. You have state versus federal, you have local prosecutor, U.S. attorney, you have civil versus criminal, you have 1983 civil actions and state civil actions of assault or unlawful arrest. You have issues about employer liability. You have some people sue the officer and also sue his or her spouse. And then that is like, what is the spouse doing there? She didn't beat up on anybody, but the community property state. So it's very difficult for the media to cover some of these cases and be expected. Somebody like Mike, a grizzled veteran of many decades, is not
Just don't be calling me
is not going to be reporting to Monique at KRO TV. Maybe Brian Johnson was that way, but your people go out to cover a case like this. They have no idea what Michael's talking about.
No, none. And I'm sorry, I just need to say something quickly
Yeah.
to the comment that you made, Ann, about.
You can sit down now, Mike. Thanks. Put the paper bag back over your head. Yeah.
About the way officers' lives are affected by media coverage. I think maybe you two have had the same experience. I have never had an officer involved in a case or his or her spouse or family members or anything ever offer an interview where it was turned down.
That's because they have lawyers.
Right, and that's, but I'm saying that as far as the responsibility on the part of the journalists, we are doing what we're supposed to do. If
I agree.
If there are other things holding back giving a more full story, it's not because we don't want to record.
I appreciate that, but the fact is that these officers have to live their lives at the end of the day, and I have had my officers on the radio. I've had them talk to the media. It depends on the case. But the fact is also they don't need to give a statement to the media. And like I've been saying all along, the media route is different, I think, than the legal route. I do both. I have to work in both worlds. But I'm a little bit scared of the media world when I'm defending cops these days, or in the past. I mean, it's difficult. It's like you come in with a police officer, and it's like what to pick a jury. And again, disagree with Steve. It's a different day and age. It's a national conversation. It's Ferguson. It's Zimmerman. I'm just saying. I'm the lawyer, so I'm looking at it from my perspective, which is I'm defending this person.
And
I'm defending this department.
Let me just plug for mainstream media for a second.
Yeah, you guys are great. In Seattle, everyone's great. But.
Well, no, I'm just saying that what influences public opinion is so much more driven now by things outside of the mainstream media.
I'm with you on that.
Yeah, it's so. I mean, we still do vetting of information.
Not like
and-
Twitter and all the,
Right,
all the
right. That stuff will be
Instagram
out
and-
there. So if I need to use that as an excuse
the stranger.
to fight more for actually dealing with the media, then I would put
You're
that out
absolutely
there.
right.
And that's a good point to close here, is Brian, you came from New York originally. Now, I know it was a different era and a different mayor, but how it's handled in Seattle compared to what you saw back in New York? Just in terms of transparency, cooperative ventures between state and feds, things like that.
You know, it's actually a hard question to answer because I think there were a lot more similarities when I arrived in Seattle in 2010 than there
Yes.
are now.
So that 5 years is a big change all over.
I mean, there's a lot happening nationally. And I know there's been major changes in New York, too, in terms of their transparency, their new inspector general. There's a lot going on there. So, you know, what I...
Everyone's copying the consent decree.
There we go.
Well, we do have, we call it the Compliance Tourism Bureau. We've had, I think, 17 departments come out to find out what it is we're doing and how we're getting past.
Yeah, both
That's why they're
Brian.
building that new hotel right by the.
Yes. Both Brian and Jenny worked on the consent decree, and of course Pete did also. And you know, the decision that the city made to cooperate rather than fight tooth and nail was the beginning of turning the entire ship around. And
Although I am intrigued by your use of the past tense. Is it over?
Oh, I guess Judge Robert hasn't made the announcement yet. Yeah, no, it's not over yet. But
It's a reform is a destination. I mean, a process, not a destination.
yes, and that's from the attorney who represents FIFA. So you know that she means that. So I want to thank my panel so much, and would you please give them a nice round of applause?